Managing conflicts of interest in a forensic expert witness practice may appear to be a boring procedural issue, but failure to understand the importance of conflicts can be devastating to your success as an expert witness. Pay attention to the following handful of tactics for dealing with this important issue. This is an excerpt from my longer video series, The Art of Expert Witness Testimony. To see all these tactics in context, get my treatise, Mastering the Art of Expert Witness Testimony. It costs a fraction of your hourly billing rate, and you can't competently practice without this information. Listen up. Turning to the second practice management area in this video. Dealing with real and potential conflicts of interest is a major administrative issue in managing a forensic consulting practice. Failure to understand the nuances of conflicts exposes you to the unexpected removal from a case, possible liability to your client, and the requirement to return fees earned to date. These are important considerations. In substance, a conflict of interest exists when a professional's ability to present an issue for a client may be impaired by current, prior, or possible future relationships with another party to the litigation. In simple terms, a conflict almost certainly exists if the expert or her firm has had any prior relationship with a client who is presently adverse to the current client of the expert. As a general proposition, the forensic consultant cannot accept an assignment adverse to a present or former client. I want to get your attention now before I spend a few minutes digging into the substance of conflicts by saying this. Whether or not a conflict really exists in a case almost doesn't matter. Once it's asserted that there is a conflict, if there's any remote basis to conclude that there is, you might as well forget about it. You're probably done with your work in the case. Successfully defending yourself from a claim of conflict of interest happens prospectively, on the front end of your retention in a case, not after the allegation of conflict is raised against you. That's too late to defend yourself. Here's what sometimes happens in these cases, and I fully admit there may not truly be a conflict of interest when this happens. You or somebody in your firm receives a phone call about possibly being retained in a case. Some minimal details of the case are discussed, and I mean minimal details. Name, rank, and serial number, so to speak. Then nothing happens. No further contact from this lawyer or client occurs. Many months later, or even years, you or one of your partners is retained and does a substantial amount of work. At the time of the deposition or other late time in the present case, the other side remembers that somebody had a phone call with you or one of your partners last year. Now, the other side doesn't like your opinion, and they would like to get you out of the case. They remember the phone call, they bring it up, and they allege that confidential information was exchanged in the earlier call. And they say you received that information, not specifically described, and they move to exclude you as a witness in the case. At this point in the matter, unless you had clear procedures in your practice and you have good documentation of this minimal earlier communication, you're essentially finished with your work in the case. Why? Nobody wants to try to defend your continued involvement against the claim that you are tainted with confidential information. Your side's lawyer doesn't want to defend against this tangential issue. A court doesn't want to protect you. You're pretty much finished. So, how do you protect yourself from this disaster? Number one, understand that the issue of conflicts of interest arises immediately with any communication from a potential client in the marketplace. You must undertake management practices to protect yourself from the possible later claim of conflict of interest. You do this by having clear procedures in place for communications with potential new clients. And your firm must meticulously track past and present clients, adverse parties, and co-parties to litigation matters, as well as regular clients of the firm. These conflict tracking procedures are essential to competently run a forensic consulting practice. So here's my suggested handling of the new client phone call. First, I suggest you not even accept a telephone call from a potential new client without formally clearing conflicts. In my firm, initial calls are routinely transferred to a senior administrative person who is trained to obtain the information that is necessary to perform a conflicts check. Name of case, legal case number, all parties and their counsel, adverse parties and their counsel. Only after conflicts are cleared does the forensic professional communicate with the potential client. This practice ensures that you can accept the present assignment without fear that you'll later be conflicted out of the case because of some past communication or employment by you or other members of your firm. The initial telephone conversation procedures merit additional discussion here. If the expert directly receives a telephone inquiry from a potential client, the expert should immediately take control of the conversation. Advise the potential client that the expert does not consider himself retained and ask the potential client to limit this initial conversation to administrative details: case name, parties, lawyers, and adverse parties. The expert's proffered reason for deferring a substantive discussion is to check conflicts, and that is a true statement. At this point, the expert can't be certain that she or her firm has not had previous conversations or performed services for the other side of the dispute. In short, a conflict may already exist, preventing the consultant from being retained by the potential client. It's advisable to have the potential client email a pleading caption sheet so that a formal conflict check can be made. Absolutely no substantive discussion of the facts or strategies of the case should be undertaken in this initial telephone call. Advise the potential client that you will clear conflicts and return the phone call as soon as possible. If this practice management procedure is not undertaken with respect to initial telephone calls, 3 problems can occur. First, you may find yourself engaged in a substantive conversation about facts of a particular case only to learn that you or one of your partners has already been retained by the other side or performed some services for the other side. If this happens, the likely remedy will be completely withdrawing from the matter and possibly returning all fees that have been paid to date. Second, if you engage in a substantive conversation about a case in an initial telephone call and the potential client chooses not to contact you again, you'll find yourself conflicted from ever accepting work in this matter from the other side. It only takes one 5-minute conversation that precludes you from a subsequent $15,000 professional fee to learn this lesson. Regrettably, I've made this mistake several times over the years. The third problem that arises from loosely engaging in an initial telephone call is that you lose control of your ability to choose the cases and clients that you want. One of the advantages to limiting the initial conversation to a brief, non-substantive outline of the case is that it enables you to step back and consider whether you want to work for this client, this attorney, or on this matter. By removing yourself from the initial phone conversation to clear conflicts, not only will you truly clear conflicts, but you will also have the opportunity to pause and consider whether you want to accept this assignment. Your subsequent telephone call with the attorney will be much more organized, and you will be managing your litigation practice proactively, not reactively. I suggest you develop a checklist for gathering information during initial telephone calls and follow the list scrupulously. Another practice management consideration regarding conflicts is the actual conflict management program that you implement. Any significant litigation practice will require a computer database program to manage its conflicts. It's impossible to track conflicts informally. If your litigation services practice grows to any meaningful size, meaning more than 1 or 2 cases per year, conflicts must be tracked by a computer database management system. The short answer to this complicated dilemma of conflicts is to implement practice management procedures within your firm. There's no way around the issue. Conflicts are a serious matter in a forensic consulting practice, and they must be competently dealt with. An unfortunate final point regarding conflicts of interest is that some lawyers or clients have a practice of contacting experts at the outset of a case simply to conflict those experts from being retained by the other side of the litigation. Although this practice borders on unethical, it is certainly undertaken, and it has happened to me more than once over the years. Very tight initial communication procedures will help the forensic consultant defend against this improper conduct on the part of some unscrupulous lawyers. Finally, if you find yourself wanting to be retained in a case in which you have a conflict of interest, you can try to obtain a waiver of conflict from the opposing party. This is a complicated legal procedure, and I suggest you involve all the lawyers in the case to obtain the waiver. But in a sense, you have little to lose by trying to get the conflict waived because you can't be otherwise retained. In conclusion, the adversarial environment gives rise to practice management considerations that are unique to a litigation services practice. Non-litigation professional practices don't need to be concerned with conflict of interest issues, nor do they fear every aspect of their work being scrutinized by an opposing party. Structuring the management of your expert witness practice to address these considerations will help contribute to your success as a litigation services practitioner.
Brian Peter Brinig is an adjunct professor at the University of San Diego School of Law and managing director of the forensic consulting group of CBIZ, a national financial services firm. The strategies and tactics presented in this video presentation are discussed in complete detail in his treatise, Mastering the Art of Expert Witness Testimony, which is available by scanning the QR code on the screen or on Amazon.